इस वीडियो में आप देखोगे आर्गुमेंट्स पिटिशनर की तरफ से एडवोकेट्स ने रखे कि जम्मू एंड कश्मीर जिनमें जो कॉन्स्टिट्यूशन बना था लोगों के इलेक्शन के बाद बना था। जिस प्रकार से हम जानते हैं कि इंडिया में जो कॉन्स्टिट्यूएंट असेंबली बनी थी बिना इलेक्शन के, वो बनी थी इलेक्शन से पहले, और उन्होंने कॉन्स्टिट्यूशन बनाया था। और यहीं पर जो जम्मू कश्मीर का कॉन्स्टिट्यूशन बना था उसमें इलेक्टेड मेंबर्स थे, उन्होंने कॉन्स्टिट्यूशन बनाया था। और ये आर्ग्यूमेंट्स रखे हैं, कुछ रेफरेंस दिए, जजमेंट के रेफरेंस देकर उन्होंने कहा कि सॉवरेनिटी को लेकर वो सब आप देखोगे, और एक्सप्लेन करके उन्होंने किस तरीके से अपने आर्गूमेंट्स रखे हैं 370 के एब्रोगेशन के अगेंस्ट और सॉवरेनिटी पर। मोस्टली आप इस वीडियो को देखोगे कि किस तरीके से उन्होंने अपने आर्गूमेंट्स रखे कि लोगों की कंसल्टेशन आवश्यक थी, जो एब्रोगेशन आर्टिकल 370 का हुआ उसके लिए कंसल्टेशन इम्पॉर्टेंट थी। और किस तरीके से उन्होंने इस आर्गुमेंट को फ्रेम करके बोला है वो आप इस वीडियो में देखो।
Question when only instrument of execution is executed, that's all. No merger agreement, no supplementary agreement, nothing of that sort. What is its legal status? They categorically rule that the sovereignty will continue to vest in the ruler. This is what is in this judgment. Paragraph 11 of that judgment, well, let's see that. Paragraph 11 of the judgment. I'll have read it, but I don't want to waste time.
Yes, you have read it already.
By my colleagues.
Yes.
That's 11 expressly rules that. So on that basis, I'm saying, because earlier my lord's views were slightly different, but Justice Khanna's views were different. So I'm just citing the judgment, the constitutional bench decision, saying that the.
You said 135.
Paragraph 11.
PDF is 135.
PDF is what?
Shah, these are
No,
just
PDF.
questions and queries. These are just questions and queries, just like you, this side, other side. These are just questions and queries. That's all.
No, my lord's asking me the question. I was just trying to respond to that. So my first proposition was that Maharaja retained his sovereignty. That's all I'm saying. Now, I also use the word, he retained residual sovereignty, if you lordship may recall.
Yes.
So residual sovereignty remained with him. Then what happened? After it was retained by the Maharaja, later on, at what stage it got transferred over to the people? It did not go into Article 1. It did not go into Article 370. That's what I'm trying to say. It has gone to the people. And it is in exercise of that residual sovereignty that the Constitution of Jammu and Kashmir was made. This is what I'm trying to say. It's incidentally meeting arguments of the respondents also that it was a concession, it was with our permission, so on and so
To
forth.
that extent, you're taking a different projection from others. There's a different argument as to what was argued by Mr. Sibal and others.
No, but on the question of sovereignty we are, I don't think there should be much. And it begins with the expression, we the people of state of Jammu and Kashmir. That should be enough to indicate that it's by itself an independent, separate constitution. But to say that this is inferior, to say it is subordinate right is something unpalatable to us, that we feel that this is our constitution, like people of India would feel proud that they have a constitution, which though in our case, we had proper elections, and then only we had representatives who made this constitution, unlike the Constitution of India, which was that no elections took place for forming Constituent Assembly. They were the representatives of various provinces. So we're on a better footing. Now, this constitution, which we made for ourselves, what did it do? In section 3, it said, now we are calling our constitution section, whereas that of Indian constitution as articles. This is also another thing which has slipped into our language. Actually, my constitution also has articles. This section 3, my lords, straightway stated that it shall be an integral part. That's the same position as taken in Article 1R, instrument of extraction. That's there. But what's important is that when it says we will redefine our constitutional relationship, which was read in the morning, it is in the preamble itself. Now, what would exactly mean redefining constitutional relationships? What was the earlier constitutional relationship which we had, and it had to be redefined. It had to be enlarged or reduced or whatever was to be done. So we have two different entities, the Union of India and a federating unit. Between them, This was the mechanism in terms of which they would redefine their constitutional relationship from time to time.
Not redefined, further.
Further defined constitutional relationship.
Yes.
This has happened from time to time. That's what the CEOs explain that from time to time, there was further defining of the constitution. Prior to that, what we had was only instrument of accession, and then 1950 order, then 52 order, then ultimately they got merged in 1954 order. Subsequent COs are all amendments made in 54 order. They are not independent by themselves. Why it was so? Because 54 order had been initiated by the Constituent Assembly itself. One of the issues which Mr. Subramanian also pointed out, I have a judgment, division by judgment of the High Court of Jammu and Kashmir, where they have gone into this question that it was initiated by the Constituent Assembly itself. That you also will see. This is in AIR 1971, Jammu and Kashmir, page 120. Justice First Lady has gone into this question. I will just read it quickly because we didn't have time to add to your lordship, so I'll just read it. So I read it for lordship convenience. Your lordship may not have a copy of it.
Yes.
It simply says, I, Yuraj, do hereby direct as follows: a Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution for the Jammu and Kashmir. This was published in Government Gazette on 1st of May 1951. In obedience, this is court finding. In obedience to this proclamation, a Constituent Assembly was convened for the first time on 5th November 1951, as mentioned by petition para 13 of the amended petition. On 15th February 1954, the Constituent Assembly passed a resolution adopting the report of the drafting committee and the annexure thereto, and thus by doing so, the Assembly gave its concurrence to the application of certain provisions of the Constitution of India to the state in the manner indicated in the annexure. The resolution of the Constituent Assembly may be quoted thus. Then they quote that following Government of India. Now, this only leads to the conclusion that the process was initiated by the Constituent Assembly itself, forwarded to the Government of India. The President accepted this, and then 1954 extension order was passed. This gives the source, the history as to how this 54 order has come into existence.
Yes.
After this comes into existence, then follow the later on, as many as in all, 54 constitution application orders have been passed. Out of them, this one is by the Constituent Assembly. Remaining others are by the government of the state. And those are in the nature of amending this constitution application order of 1954. Because they could not do it otherwise. This is another aspect you also need to consider. This was approved by Constituent Assembly. Others were not. So what they did was, all these years, they have been amending that particular order. Now, sir, as a result of these constitution application orders, what happens is that, which will also found interesting, ocean of my constitutional autonomy was reduced to a pond by 4th of August 2019. Whatever it was just to call it, it's a skeleton. I would not like to call it, but we still had. What was that fundamentally I had on that date? Broadly, I have given that in writing also broadly. I had my own permanent residence was one. I had the jobs reserved for the people who are permanent residents to only in the state government services. Number three, nobody could acquire the land. These were three fundamental things which I had as on that date. Then, of course, we consider it to be our identity. This 370 was in the nature of the identity of the people of state of Jammu and Kashmir, culturally and otherwise also. Linguistically also, different languages were spoken in Ladakh, Ladakhi, in Jammu, Dogra, in Kashmir, Kashmiri. So over these 70 years, a certain kind of interaction, mixing up of these languages, cultures had taken place, and it had evolved itself into a certain kind of a culture, which is a complete harmonious relationship between these three regions. This was the effect from time to time, and nobody questioned these CEOs also for all these years, that why are you shrinking our constitutional autonomy? And I had raised an argument last time also. I said that by conceding that the Parliament of India will have power of legislation over me, I was indirectly reducing the power of my own legislature, which otherwise it had. Name any act. I gave an example, there also Tada Act. My own legislature could have made it. But then this state cabinet recommended through the governor, you apply 97 in a specified manner, and we had Indian Tada Act applicable to us. Of course, that's the fate of the history as it is. But whatever was left, it was there as on 4th. Now, when you take this decision, what is to be done on now 4th? Somebody took the decision that we want to get rid of it. Why should we get rid of it? That I still don't understand. Why can't the Union of India accept there can be two constitutions? Why can't Union of India accept that it's a kind of a federation in which there can be two constitutions? There are examples all over the world where there can be two constitutions. It is not this solitary case in the world. Why can't that fact be accepted? Third, when you accept that you are an integral part of it, yet you have this constitutional autonomy between total integration, total merger, and some space between the state and them for historical reasons, not of its own, for historical reasons. That's an important part of it. So therefore, there were some problems, some circumstances, rightly said by the respondents themselves, there were circumstances, situations in which it was felt by whom? By both the leaders of Union of India as well as the leaders of Jammu and Kashmir to provide this space for this autonomy to the people of the state. We're not going to the why this autonomy was given, but the fact of the constitutional position that this autonomy was given to us. And this autonomy could be taken, as all the councils have correctly stated, by concurrence, by consultation. You could take it away from us. We had to concede. We were on the giving side because it was with us. We had to do